I want to set the stage a little bit. I frankly did not think that I'd be lucky enough to be here today. I had something yesterday that I thought was going to keep me away. So AJ had agreed to serve as MC. So I'm grateful very much for that. And it seems so fitting, right, to have this sort of bridge of time, which is exciting. But I want to set the stage a little bit. 1974 was when Nell began with the firm. Mr. Amy, who I understand was only ever called Mr. E, was the managing partner of the firm. We had one office. It was Baltimore. And the firm obviously has grown tremendously during that time period and is now a national firm with so many various practices. But we here in Baltimore appreciate that the soul of the firm is here, that the foundation of the firm is here, and we're incredibly proud of that. AJ is going to have a chance to explore some of that now. I'll speak very briefly at the end. And then I think that Marianne will have the ultimate last question after I say a couple of things at the end. But I'm just so excited to be able to draw these connections from the history of the firm and relate that to the present in ways that I believe, at least for me, are really empowering and exciting, affirming. And so I'm grateful for Nell to take time out of her busy life. We had to work this around a Moroccan vacation, for example, to join us. So now, AJ, I'll go to AJ first.
Yeah. So thank you so much. I appreciate it. That was obviously very helpful context for many of us to kind of envision where we were at that time when Nell was at the firm. I just want to give a little bit more context to her professional career. She graduated from Whitman University in Whitman College. I'm sorry, in 1962, and with a bachelor's of arts, and then worked at Harvard Business School, teaching MBAs how to write, which I think is quite a bit of foreshadowing for her later career, as everyone I talked to could not stop talking about your skills. And following teaching at Harvard Business School, she worked from the home, raising her 3 children, before attending University of Maryland starting in 1971, where she was notes editor of the Maryland Law Review, and then graduated Order of the Coit. And as Chuck mentioned, immediately after graduating from Maryland, Nell began working here at Venable. She did complex commercial litigation, emphasis on the complex. The most demanding, challenging cases that we had at the firm were the kinds of cases that Nell worked on. She was also very active in the legal community. So she was a member of the Wranglers Law Club, which is a famous law club here in Baltimore. And she was also associate editor of the Litigation Journal, which is the ABA's journal for their litigation section, from 1978 to 1983. Shortly after that, she authored an article, which I hope we're going to be able to touch on today, which is advice given 40 years ago to women in the law. And I read that article this week, and I shared it with a number of my colleagues, and we were totally bowled over by how relevant, I would say 100% of the advice. I might phrase it a tiny bit differently, but every single piece of advice in there is relevant today. In 1982, Nell became Venable's first woman partner. So obviously a star in her own right. If you were here early, you saw a line of people waiting to talk to Nell. She worked alongside many other legends here at Venable, and who in the past and who are still here today. I'm not going to rattle off any names because I'm going to defer to Nell to tell whatever story she wants to tell, but we have a number of individuals here in this room who were just so thrilled to see you today. And final note, Nell does nothing halfway. After having retired, she's now, based on my research, is a preeminent gardener, really dedicated to her garden. So we're so lucky to have you here. Thank you so much for joining us, and I will cede the floor to you.
Thank you. It's a pleasure to be here, and I appreciate you all coming. The 2 things that I loved most about working at Venable were the extraordinarily high level of practice. The Venable standard of practice competed favorably with the big firms in New York and Chicago and LA and DC the quality of analysis, the high level of ethical standards, the dedication to the client's needs and solving the client's problems made the practice very satisfying. And the other thing is Venable's commitment to public service. So many Venable lawyers became assistant attorney generals or assistant states attorneys, assistant US attorneys, served in government, dedicated themselves to important community issues. And I think that's a quality that you don't find just anywhere. So those were the two qualities of working at Venable that made it outstanding to me in my experience. I want to start by painting a little picture of the landscape when I came to Venable in the fall of 1974. I had a 1-year-old at home, so they said I could start whenever I wanted to, and I picked the end of September. So I started about 6 or 7 weeks before the bar exam results came out. And by the 1st of November, I was wondering if that was such a good choice because, you know, what if the letter said we regret to inform you instead of saying we are pleased to inform you? That would be an unfortunate start. But I'd already gotten a raise. When I was hired, the starting salary was $13,500. When I started work, the starting salary was $14,500. And later that year, I got a Christmas bonus. I hadn't done anything. And I thought, this got to be a pretty good place to work if these things happen without making any effort. The firm had one telephone number. The switchboard was manned all day, I think until 7 o'clock on weekdays and Saturdays from 8 to 1. And people would call and ask for a lawyer, and the switchboard person would plug in that person. There were no cell phones, no computers, no TV ads urging you to hire this lawyer or that lawyer, no billboards. It was rather different. And the skill of a secretary that was most valued was being able to type something with 7 carbon copies and have all the carbon copies. You all know what a carbon copy is? And so if you made a mistake, you had to correct all the carbon copies back to the first page. So someone who could type that well with so few errors that all the carbon copies could be used, that was highly valued. Now, as Ashley said, I had been a teacher of writing skills. I'd been the editor of my college newspaper. I had begun in high school to type everything that I wrote. So after a couple of weeks, I asked for a typewriter. And you would have thought that I had said I was going to bring my pet elephant to work every day. Where could I put the elephant? This was outrageous. The woman who was in charge of the secretaries appeared in my office, which was half of a conference room, because they hadn't planned ahead for the new people arriving, and drew herself up and said, attorneys do not type. Attorneys dictate, and turned around and walked out. So at that time, there was an associate in the litigation department who had been a journalist before becoming a lawyer, Doug Hanna, and he had a typewriter. And he said, I am going to get you a typewriter. And he went and found one, I don't know where, and he came marching down the hall carrying the typewriter and plopped it down on my desk and said, just don't say anything to anybody, just do what you want. And that's how I started typing. So when the computers sort of inched their way into the lawyers' offices through several intermediate steps. But when we got to the point that the firm gave up on mainframe computers and went to individual desktop computers and then ultimately to laptops, that was music to my ears because it made it easier for me personally. And of course, it created efficiencies that no one, I think, had really predicted. My timekeeper number is and was 098. The summer associate's timekeeper number, I believe, was 097. So you see where I was in the pecking order. And at that time, associates were assigned to one partner, and that partner fed that associate the work. And the partner I was assigned to was actually working as sort of a senior associate to Mr. Eney. So the work I was doing went to Mr. Eney, and that was a serious motivator for being sure there were no typos, no grammatical errors. I read every case I cited at least a couple of times to be sure that I could avoid the dreaded, explain to me how that case supports that position. And it was, to say the least, it was not a glamorous way to begin the practice of law. And I would occasionally have lunch with my law school classmates, and they were doing things like going to court and taking depositions and going to client meetings. And I was sitting in the library. And so I knew Ben Civiletti from politics. And I went to him and I said, Ben, this just isn't very much fun. I'm not having fun. I have to have something better to do. And he said, all right, I'm transferring you to the litigation department starting Monday. You're assigned to Frank Murnahan. And I don't think he had the power to do that. He wasn't even on the associates committee. But I started working for Frank on Monday, and his method of training an associate was throw her in the deep end of the pool, and if she swims, great. And if not, we'll get another associate. They're pretty easy to find. He would not have phrased it quite that way. That was early 1975. So he was 2.5 years from going to Washington to be Assistant Attorney General under Jimmy Carter, from which he was a good lawyer. He worked his way up the ranks to be Attorney General. And Frank Murnahan's idea was that you don't settle a case until your opponent runs up the white flag, totally surrenders, doesn't want any money, and just walks away. Mm-hmm. So I had a lot of courtroom experience early. And the first courtroom experience was, if you all can picture the courtroom east on Calvert Street for the Circuit Court for Baltimore City, that was the U.S. federal courthouse and post office. And on the 5th floor, there were 3 huge cavernous courtrooms with heavy velvet draperies and a bench way up high. And it was like being in a cathedral. And those courtrooms were occupied by the 3 most senior federal judges. And Frank had a case, and he wanted my help, and he thought I should learn how to examine a witness. So instead of, giving me any suggestions or suggesting I observe and figure this out, he said, here are some documents, question the witness and get the documents admitted into evidence. And I had zero idea of what to do or how to do it. And Frank's sitting back. The only saving grace was that it was a non-jury situation. And I don't think he would have done it in front of a jury because he would have looked sort of, you're supposed to look like you're toadying to the jury. And so the judge leans over this huge fence and says, speak up. If you're going to say something stupid, at least speak so I can hear you. that was my first appearance in the proceeding. And later on, in a different case, that the current federal courthouse opened while the case was pending. So the actual trial that had started in the old federal courthouse moved to the new federal courthouse. At the same time, one of our partners, Joe Kaplan, was appointed a circuit court judge. And the firm decided to hold a reception for him, for all personnel, at lunchtime at the Belvedere Hotel, which, it's what, a 15-minute walk north of where the firm was in the old Mercantile building. And Frank was determined to go because Joe had been one of his colleagues. And there was a third lawyer whose name I don't remember who also went. And for some reason, I didn't go. And they didn't get back on time. And the judge came back and the jury came back and the judge said, call your next witness. And I look around for my colleagues and they weren't there. And so I called the next witness. I'd prepared the outline of questions for Frank to use, so I knew what the witness was supposed to say. And about 10 minutes into the direct examination, Frank and this other guy come in and he's like, what the, what's going on here? And I said, I had to do something. And you can't change lawyers in the middle of the examination. So he was somewhat irked. I think he should have thought I should have found a way to say that there was a reasonable excuse for them not being back on time. The actual excuse was alcohol. And I think that was the last lunch anything where the firm served free alcohol. Into too complicated that afternoon. There were insufficient staff in the building. So I hope some of you have read a book called Lessons in Chemistry. Mm. If you can get past the cover, which is not a particularly effective cover, the main character describes her difficulties as a PhD in chemistry, trying to work in a chemistry department in a university in California in the late 50s and early 60s, and getting nowhere with her male colleagues. And it sounds a little extreme, but I assure you, it is absolutely hitting the nail on the head. And if you want to know really what it was like in the bad old days, read Lessons in Chemistry. And the most charming character in the book is a dog named 630. So even if you aren't interested in the struggle of professional women, you'll be enchanted by the dog. I think generally that the practice of law, both at Venable and in Baltimore generally, is not as colorful as it used to be. There used to be, I had one case where the opposing counsel would go to his favorite dive at lunchtime and sit at the bar and drink during lunch. And if you wanted to ask a question about what witness was coming up in the afternoon, he said, oh, just call me at the bar. They know who I am. They'll put you on. And one of the colorful things, and Chris, I know you remember this, is the Friday afternoon games of rug golf. And rug golf was where you brought your putter and your golf ball and you found a suitable Persian rug, which has all kinds of places that you can assign different values to. And you try to hit your golf ball to land where you want it to land. And that was considered an appropriate way to practice law on a Friday afternoon. And it's my perception, I may be wrong, that that kind of sort of, it's not giggling, but sort of super relaxed, casual hijinks does not crop up very often at at this time. And I don't know whether that's good or bad, but I think it's valuable to be able to have fun and relax and not take everything so super, super, super seriously. You don't have to get your shirts freshly starched every weekend to be able to practice law at Venable, although it might help. Generally, my advice is work hard, do a good job, get your work in on time. Don't ever say between you and I, or do you want to go to lunch with Jim and I, because there are plenty of people here who will shudder when you say that. And the fact that you can even hear that every once in a while on NPR doesn't mean that it's accepted usage. Keep in mind, I read the New York Times with a red pencil handy in case there are any typos that need correcting. Don't complain. Lawyers are problem solvers. The client has sought legal advice because they have a problem that they need solved. And I said frequently when we would have the litigation partners would get together to evaluate the associates, and they were long, detailed, tedious, almost excruciating meetings. And I would say, there's only one thing you need to know. Does this person come to your office and say, I woke up at 3:00 in the morning and I was thinking about blah, 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 and this is how we can solve that problem? If somebody is working, if their mind is working on the problem while they're asleep, that's who you want to practice law with. You don't want someone who says, well, 5:00, I'm out of here. I had one associate once who said he couldn't do something. I don't even remember what it was. He couldn't do something because he had to go home and help his wife take their cat to the vet. And I said, well, I've had a lot of cats. And all you have to do is pick up the cat, put it in a pillowcase, tie the pillowcase shut, and throw it in your car. One person job. It's not that hard. You got to be able to do this. And it's helpful. One of the problems I think with litigation practice is you don't really have a discrete substantive area of law that you master, like tax, or ERISA law or labor law. You have a process that you master. So you can become an expert on, like, I liked punitive damages issues. I like joint tortfeasor release issues. The joint tortfeasor statute in Maryland is a complete mess. It needs a good editor. I would be happy to rewrite it for the legislature at any time so that it made sense. But if you need something that you can be really good at, and in litigation, it's the process. So it's hard to find an area within the process that you're going to be better at than anybody else, because, you know, the people here are practicing at a really high level. And I think that those are, I think the one other thing I wanted to say is when I came to Venable, it was pretty steeped in old Baltimore. And the accepted path to success was Gilman, Princeton, and the University of Virginia Law School. I went 0 for 3. And I was not the first woman hired. I was the 4th woman associate when I came. The 5th woman associate was hired a few months later, started in February. So it wasn't that there weren't women and the men were having trouble figuring that out, although Mary Ann will remember the Tupperware parties, and the women would get together for a potluck dinner, and this alarmed the management substantially. And the guy who was the assistant to the managing partner came around to ask me, as the instigator, why, what do you talk about? Why do you need to get together? And I said, Tom, don't worry. It's just a Tupperware party. and we did that for a long time. And
They used to ask us what we purchased.
Check in.
What did we buy? It's like, I got a great container to be able to.
I'll be able to bring my lunch and work at my desk. Won't that be a plus? I think it was a real problem when I became a partner that I was going to supervise men. And that clearly is against the natural order. A woman should never be in a position of directing the work or activity of a man. We all, that was stamped on everyone's foreheads. And Marianne, I think were you the first associate assigned to me? And so they sidestepped it a little bit. And I think that was sort of a concern that it took a while to work through. I assume that is no longer given a nanosecond of thought. And I think the practice of law has changed remarkably. As one of you mentioned, I just got back from Morocco, and every single person, as nearly as I could tell, had a cell phone. The women who were completely veiled and were walking down the street with big, heavy, thick glasses were talking on a cell phone. The attendants in every little shop, restaurant, hotel, everybody had a cell phone. The cell phone has changed everything. The internet has changed everything. So I suspect that if I were to pick up a file today, I wouldn't have the first idea how you do research. I would want to go to the library and look at books, books that you open and if you all want to see a really funny video on YouTube, watch the video of when the monks have to upgrade from scrolls to books. And the IT help monk has to come and show the guy how to turn the page and what to do if he wants to go back. And I feel such sympathy for that monk who couldn't figure out how to read a book and turn the page, because I'm so easily brought to a complete halt by technology. So you all have a great opportunity working here. I hope you enjoy it. I hope you have interesting things to work on. And I'd be happy to answer questions.
So while people are thinking of questions, I do have a few for you. Going back to 1974, when you first started as an associate, at that moment when you walked in the doors, were you thinking, I'm going to become a partner here? What was your thought about how your career was going to progress?
My thought was, when I started, my youngest child was 1, and the other 2 were 4 and 7. And I'm not from Baltimore. I had no family in Baltimore. I had a live-in housekeeper, and I had backup. And my thought was, how can I avoid ever letting my domestic situation become a problem? Because if I say one single thing about, I have to go home because my daughter is sick, that's the end. There would be no slack for that. But at the same time, I wanted to go home and have dinner with them. So this was a problem. And I figured out pretty early on how to do triage, and anything I could take home and work on at night after the little darlings went to sleep. And sometimes I had to pull the room darkening blinds down a little early. So they say, Mom, why do I have to go to sleep? Because I'm tired. You go to sleep. But I would take a stack home of things I could do at home that I didn't have to do in the office, and then other things that I had to do in the office, so that I could, if you're stuck in a game of whack-a-mole, you don't want to be above the board. And I wanted to stay under the board for as long as possible until I'd seen I hadn't clerked for anybody. I'd never been a summer associate. I wanted to see how I stacked up against the best and the brightest, and if I could really do it before anything happened that would suggest that I even knew what the word family meant.
What, in terms of progressing and promoting at that time, what was the mentorship or sponsorship like? Was it just you and Judge Murnahan chatting? Was it a surprise? How did it work then?
Well, I think Judge Murnahan was a tremendous protector, and I was under his wing, and he was good at protecting me, as was Ben Civiletti. But neither one of them taught me a thing about how to practice law. That was all Doug Conant, and he was probably a fifth-year associate, and he was. He and Fred Motz and Ben Rosenberg were all the same level. And they were all pretty good at telling you how to stay out of the stormy winds. And I once saw Frank Murnahan chase Fred Motz down the hall. Fred Motz, now a federal judge, chase him down the hall saying, "How do you ever expect to be a partner in this firm if you can't even write a certificate of service?" So, you had to keep your sail out of their wind at crucial moments. And Doug was helpful in he said to me early on, I was supposed to go to the Maryland District Court, which is excellent practice. You all should hope that your friends have traffic tickets and you have to go to traffic court with them, because you'll learn a lot. And it's a good place to, basically, if you show up, your client's going to get off. So it's a good place to find out if you like being in court. But I was supposed to handle this small corporate matter in the Maryland District Court. And Doug said, "What's your theory of defense?" And I said, "What do you mean, the theory of defense?" And he said, "Well, you know what the facts are, but what's the legal theory of why your client isn't liable? You have to know your theory of defense." Well, that sent me scuttling back to my desk, where I looked at all this information again to try to put it figure it out in that way. And that's very helpful advice. And I was a good writer, and I'm still a good writer, and I'm fast, and I'm good at, after I retired, I taught a writing course at Maryland Law School with Susan Gavi for 3 or 4 years, and I quit because the year of COVID, the fall of 2020, we taught the class remotely. I thought, well, this is really nice. Just sit at home at my laptop, and I don't have to get gussied up. Don't have to go downtown. The next year, they wouldn't let us teach remotely, and I said, okay. But I liked writing, and I could write quickly and fluently, and that was a big asset.
So this next question is an ulterior motive question. Laura Bouillet and I co-lead the Women at Venable group, so the Women's Affinity group in the Baltimore office. And your point about instigating, being the instigator of opportunities for women to get together and have that camaraderie really hits home. Were there other opportunities besides the quote unquote Tupperware parties where you were instigating?
Was I an instigator? I mean,
So
by
now-
nature, I'm an instigator.
She's an instigator. So I was my first child. Nell had a baby shower for me at her house. And all of the men partners thought that was wonderful. But we didn't have any men partners there. It was all women. They did.
Oh, well, That's good.
Did I do that? I got half a person.
I do have some more questions, but I want to make sure I give other people an opportunity to ask if they have any questions or any war stories that they wanted to share. Okay, you can.
I'm Hannah. I'm a summer associate. And you had mentioned that sort of when you started your career in law, your main goal at the time was to see if you could hold your own with like the best rated tier. I was wondering if there was like a moment when you realized that you could, or if it was like slow sort of progression as like with small victories.
Well, there were several moments where I thought I can do that better than that guy is doing it, which, you know, you can't go around saying that. There was a case. I love this case. The Mercantile Bank had been sued for allegedly dispersing funds without a valid signature by the account holder, who the account holder claimed that the signature was forged. And the other side had made a motion for summary judgment, and the partner handling this case put the file is about that thick. One thing that is so different now is you have cases with thousands of pages of documents, and the invention of the Xerox machine just fed that desire, and email has made it 10 times worse. But this was, I'm thinking, late 70s, and the whole file was about that thick. All the pleadings, all the documents, all the correspondence with the client. And the partner put the file on my desk and said, "This case is going to go to trial in a week or so. Would you handle it, please?" So I looked at it, and the other side had filed a motion for summary judgment that we had not answered. And I was a little alarmed by that, because I thought it would be a good idea to oppose a motion for summary judgment. Yeah, it would be helpful. So I dithered around about what to do, and I talked this over with my pal, Doug Connett, and he said, "Well, you got to tell him that you're opposing the motion, and just oppose it, do the draft, put it on his desk, say, just sign this and we'll get it filed." And so I did that, and he looked at it and said, "Well, I don't think there's any reason why we should even bother filing this. I mean, anybody could tell they don't merit summary judgment, but you've already written it, so I'll sign it." So he signed it. So the motion for summary judgment is denied. We go down to the courtroom to try the case in Upper Marlboro, Prince George's County. Hot June day, humid, no air conditioning. We come back from lunch, and I look up, and the judge is. It's a non-jury case, and I thought, well, you know, the judge can sleep through some of this, but there are a few facts that the judge really needs to understand. What can I do? So I had a stack of books from what used to be the Court of Appeals sitting on the edge of the trial table, and so I knocked them over. They made a huge crash. The judge set up, and so then I started speaking in an even louder voice and parading around I like to wander around the courtroom when I'm examining a witness, so I wandered a little closer to his area so that he had to pay attention. So then when we left the courtroom, it was so hot and so awful. We're driving back to Baltimore, and the bank's general counsel is sitting next to me in the front seat. And I said, "You know, we really need to stop and get a beer." And he's, do what? I said, oh, look, there's a place. And we pull over and I run in and come back with a 6-pack of beer. And of course, then everyone in the car had a beer. And in those days, it wasn't automatically a jail sentence. Drinking a beer while you were driving the car. So does that count as powerful?
Yes.
Yeah.
Yeah, that's the picture. So I did have a question. So I did prep you on this, but I want to make sure you have a copy. 2 years after you made partner, you wrote the article I referenced earlier. That's a map for women on the road to success. Yes. Do you recognize it? Consistent with your recollection?
Oh, I reread it yesterday.
Is that your
You ever seen this document? No. Well, look here, they gave it to me. It says right at the
And I was wondering what inspired you to write 2 years into your partnership?
Somebody asked me. I don't. I was on the board of Litigation Magazine, and somebody asked me to, at the time, the Chicago law firms had numerous women partners. It was not a unicorn type of situation. New York had quite a few, Los Angeles had quite a few, but Chicago was the leader in that regard. So there were lots of people who could have done this, and somebody just asked me to do it, and I did.
Yeah. So as I mentioned, it's a lot of the same advice in this article. I'm happy to send to anyone who's interested. Applies now, and I was wondering if you had any insight on why do you think the same advice that was 40 years ago still applies to women in the profession?
I think it applies to anyone in the profession. I think anyone who, the subtext of this is to be very politically aware of the environment. If you're going to pick a fight with someone, know who you're picking the fight with, know what the stakes are, know what the blowback to you is going to be. Don't get into a shouting match with someone who's in a position to get you fired. I mean, it's just, there's a lot of, I think to be a good trial lawyer in particular, you need to be a pretty good psychologist, and you need to understand the dynamic of what's going on. And read Scott Turow's book, Presumed Innocent, does a fabulous job of addressing the dynamic of a prosecutor and a judge and a defense attorney who had a lot of cases before the current case, and they're going to have a lot of cases after the current case, and nobody's going to risk his whole professional reputation on this one case right here. Just to understand the tugs and pulls of what's going on. And can I tell one more war story?
Please tell many war stories this year.
So I was court appointed to be court appointed in the federal court to defend a criminal defendant. You have to actually demonstrate that you know what you're doing. But in the old days, they just grabbed someone. And when I was court appointed, I did not know that the rules of criminal procedure were in a separate book from the rules of civil procedure. I'm looking in my rule book, and I was court appointed to represent one of the co-defendants in a 12-defendant drug conspiracy trial. And as anyone in the U.S. Attorney's Office would tell you, the government does not lose drug conspiracy cases. And to prove the point, they sent over a stack of transcripts of tape recordings like that of my client discussing with his co-defendants how much product to sell, how much to charge for it, how to deliver it, what the quality was. And the informant kept trying to change the subject in these conversations. And my dear client kept changing it back. So when are we going to get the delivery? How much can you get me? And I thought, this is just hopeless. This guy is dead in the water. And these defendants had all been students at the University of Akron together. And so it was a well-educated conspiracy. And one of the defendants who had made a deal with the U.S. Attorney's Office to testify against the others was a young woman whose father was a bigwig of some kind in Akron. And he was horrified. And he said, you're going to make the deal. You're going to do what they tell you to do. You're not going to jail, blah, blah, blah. So she gets on the witness stand and she's not being responsive to the questions. She's saying, I don't know. I don't remember. I don't understand. I can't help you with that. And the U.S. attorney, having assumed that they always win, so he hadn't really prepared very much, he's getting more and more frustrated. And as I saw him getting more and more frustrated, I started objecting more and more. And he asked the judge for permission to lead the witness. And the judge said no, said she's not adverse to you. She's just not giving you what you want. And that's not a reason for being able to lead a witness. So the government's case sort of fell apart. And the defendants were found not guilty. And the assistant U.S. attorney was apoplectic. How could this happen? Clear miscarriage of justice, which it probably was, except these guys weren't going to do anything more. They sort of hopefully learned their lesson and found something that took advantage of the fact that they were well educated. And so a couple of days later, the assistant who tried the case filed a request with the judge to bring the jury in to have a little discussion of why they reached the verdict they did. And the judge asked me, what is the position of the defendants to that request? And I said, well, I think it's fine, but these jurors did the best they could. They were well motivated, and they should, under no circumstances, be given the impression that they screwed up. They did the best they could, and we don't want anybody to leave thinking that they should have found him guilty and they blew it. And the judge said, well, that's reasonable, so we'll take care. So they come in, not all of them came, but some of them came, and they're sitting around, and the prosecutor's there, and I'm there, and the judge's there, and the judge says, now, before we begin, I would just like to ask generally, how could such obviously guilty people be found not guilty? And I'm not particularly tolerant of people who don't do a good job to begin with, but judges who don't do a good job really, that really rankles with me. And I thought, and the jurors defended themselves quite ably. I did everything I could to help them, but he kept telling me to shut up. So amazing, isn't it?
Yeah.
Any other questions? So now, look, I want to say thank you for two distinct things. First, we trade on your reputation every day. Literally, the reputation of this firm.
That's very kind of you.
Helped to form over many, many years, and it redounds to all of our individual benefit. And it's something that is a humbling thing for all of us to acknowledge and recognize. But this setting was an opportunity to say thank you.
Thank you.
And in addition, I want to thank you for the challenge that your excellence creates for each of us. I wonder sometimes if we're good enough, if we've earned the right to be called lawyers of Venable. And I ask that question because, in part, of your excellence.
Thank you. You're very kind.
Well, so the gift and the challenge that you've provided to us, I wish in this very public setting to say thank you for.
Thank you.
It really is. It's a great honor to have you here.
Thank you. I appreciate it.
And I know there was a party when you made partner. And I think that Marianne has a question about that party.
In the snowstorm.
That's right. I might have told you from context clues, was very, very fortunate that I started in 1981 before Nell became partner. So I think that's how they futzed with the rule about not, in terms of a woman. So I was assigned to Nell. It was every indication that she was going to make partner. So for me, it was like, oh gosh, I'm not going to ask her what she thought of me, because I owe my career to Nell because of the way she taught me to think as a lawyer and conduct myself as a lawyer. And so to answer the question of Nell knowing she would make it, I can't imagine she ever showed anything other than the fact that she was in 100% control. Even when she was saying, I don't understand what that is, tell me about that. She made the other person think that they were an idiot, that they needed to do that and they better do it right away. I mean, so just the way she her comportment and conducted herself was a huge way of getting yourself to be a good lawyer. And so I was excited to be Nell's first associate or woman associate when I knew that this amazing woman that I could tell was just so above and beyond all the rest of the people around was going to be made a woman partner. How did you feel when they finally said, yes, Nell, you're going to make partner? And how soon in advance of when they actually vote on you in the wintertime? Because I started in September, or right at the beginning of September, but they don't really tell you your partner until till the wintertime. Did you have much trepidation? Did you know that you were going to make it?
Well, at the time there was a pretty strong practice of firing associates who weren't going to make partner. So reading the tea leaves, I thought, and the year before, the head of the litigation department had said next year's your year. So just don't get mad and leave.
So what I thought was cool, and that Chuck actually was kind enough to do this, is it still reminds me to this day with your secretary, Barb. And so I was, kind of what I was always doing was trying to observe and trying to stay in the background as much as possible, but observing everything that Nell was going and she was doing all the time. To me, what stands out vividly is your secretary, which we, called then, so I guess is also a bad thing, but that's what but Barb, your secretary, she was just as excited about as everyone else. And I just remember everybody clamoring and coming in because we knew that this woman was not just the first woman partner in Venable, but in the whole Baltimore, Maryland kind of legal scene, that she had been made a woman partner. And so they had a cake, and it doesn't look like this cake, but do you remember that this was on your cake? Because I distinctly remember how cool was it when Barb got you a cake that said, howdy, partner.
Oh my gosh. Jim Forsterman and Bob Haynes for the.
It's delightful. And for those of you who were in our summer class, so the class of 2023, you will be our class of 2024, which will be 50 years to the day or whenever it happens of now starting with it. So it seems fitting to be with you guys today. So help yourself to some cake. Nell, thank you again.